Good evening. We're back with our conversations, and we're going to make this a more regular feature, mainly because there's a lot of developments in the legal and political space that we're getting a lot of questions about. Our audience wants to understand what's happening, specifically legally. And this is what has happened. Rahul Gandhi has been disqualified as a member of parliament. Rahul Gandhi has been disqualified as a member of parliament a day after a court in Gujarat found him guilty of criminal defamation and charged and sentenced him to 2 years in jail. That's a 2 year jail sentence. Now, there have been a lot of questions that have popped up about the legality of all of this. So that's what we're here to sort of explain. Now, to begin with, this happened during the 2019 election rallies in Karnataka. Rahul Gandhi made a statement, and I quote this statement. It was in Hindi. It said, Nirav Modi, Lalit Modi, Narendra Modi, how come they all have the common Modi surname? How come all thieves have Modi as a common surname? End quote. Now, the complaint against the Congress leader was filed by BJP MLA and former Gujarat Minister Purnesh Modi. The accusation was that his statement defames the entire Modi community, defames everybody with the surname Modi. Now, what has happened after that? There is a law in place that says someone who's currently a sitting MP or an MLA elected to government in either state or center will be disqualified within 7 days of the order if they're convicted of a crime with a sentence of 2 years or more. Now, Rahul Gandhi was convicted at exactly 2 years. Now, from what we understand, this disqualification is for the entire length of the conviction plus 6 more years. So, in Rahul Gandhi's case, it would mean that he cannot contest an election or be a member of parliament for 8 more years. Now, also, from what we understand, the disqualification is triggered by the conviction. So it's not like the notice sent to him by the Speaker of Parliament triggered the disqualification. As soon as he was convicted, he was automatically disqualified. Now, this is what we've understood so far, but there are many questions that arise. For example, the judgment under the defamation case itself, under the defamation law, there's some questions there. The speed at which that disqualification took place in less than 24 hours, what happens now, and our understanding of freedom of speech in India altogether. To help us understand all of this, we have Mr. Sanjay Hegde join us right now, Senior Advocate at the Supreme Court. Mr. Hegde, thank you so much for joining us on a Saturday evening. Good evening to you. It's a pleasure to have this conversation with you. Let me start.
Thank you, Faye. It's always been a pleasure.
Let me start, Mr. Hegde, by understanding defamation. Now, we have freedom of speech in India. One of the conditions under which we have freedom of speech and expression in India is defamation. My understanding is that defamation need necessarily mean that that the person who has committed the crime has to defame or lie about someone in a manner that reduces that person's hard-earned reputation. But is it true, Mr. Hegde, that this can apply to a community? Can criminal defamation apply to an entire community? Like in this case, everybody with the surname Modi.
Now, everybody with the surname Modi may not belong to the same community. You've had Sir Homi Modi, whose children Pilu Modi and Rusi Modi, they were all Parsis. Now you have Lalit Modi, who, to the best of my knowledge, is a Banya, Lala Gujarmal Modi's grandson. So to say that the Ganchi Modis of Gujarat as a community were affected is to say that, if somebody said that everybody called Hegde was X or Y, then the Jain Hegdes could object, the Bant Hegdes could object, the Brahmin Hegdes could object. That sharing a common surname does not come to in my respectful view within the mischief of explanation 2 of the defamation section. Explanation 2 says, it may amount to defamation to make an imputation concerning a company or an association or collection of persons as such. It cannot be a random, arbitrary collection just with a common surname. There is a case which was decided by the Supreme Court uh, from Aligarh, where there was a specific allegation that the prosecutors in the city of Aligarh, some of them indulged in corruption. Then, when you have an identified class of citizens, here, here, what was the imputation itself? The imputation was Nirav Modi, Lalit Modi, Narendra Modi. How come everybody with that surname? Uh, I won't repeat what was said, but is controversial. Would that amount to defamation of a class of Modis? Modis by themselves, as a class of people coming within explanation too? I am not too sure.
Mr. Hegde, does
That's
the
only a
defamation
definitional
law?
problem. Just one
Yes.
minute. That's only a definitional problem according to the section. There are several other problems of procedure and everything, and including the severity of the sentence, which can also be taken issue with as far as the defamation judgment is concerned. The Surat judgment is concerned.
The Surat judgment. In fact, if I'm not mistaken, isn't it also necessary that the aggrieved party in criminal defamation be the one who files the case or files the complaint?
Yes, and therefore the question arises: how was Mr. Purnesh Modi aggrieved, except by the coincidence that he shared the Modi surname? Now, how would he prove that Mr. Rahul Gandhi in Kolar, Karnataka, intended to defame Mr. Purnesh Modi of Surat, Gujarat? And
Yes.
and the Supreme Court in Subramaniam Swami's case, where the constitutionality of defamation was concerned, expressly told the magistrates before whom such complaints were made to examine whether they had jurisdiction in such cases at all. I believe the Surat judgment, which is in Gujarati, refers to this requirement but returns no finding on it.
So, do you believe, Mr. Hegde, that the judgment that's come out of Surat right now from that court should be, or there's legal merit in appealing against this judgment because there are issues in your mind in this judgment?
I would go further. I would say that the Surat judgment is unlikely to survive an appeal. But when will that appeal be heard? How long will it take? That's a question that I may not be able to answer. Especially, I do not know the conditions in the district court in the sessions court in Surat, as well as the High Court. The real question is what happens in the meanwhile. Is there an interim stay of conviction, or is there only an interim stay of the sentence alone? On that interim order, a whole host of consequences will hinge.
So we're not really clear what happens now, but I also want to clarify this one thing. There have been a lot of questions, Mr. Hegde. Now moving to the matter that has now been raised in Parliament. The conviction was brought to the Speaker's notice. The Speaker issued a notice then to Mr. Rahul Gandhi. Within 24 hours, his disqualification was brought about. But is it not true that the order itself amounts to disqualification? And so accusing the Speaker of acting fast or too fast is perhaps not valid here.
The disqualification section comes from 8.3 of the Representation of People's Act.
Yes.
Which says that anybody who has been convicted and sentenced to over 2 years imprisonment will stand disqualified. The Supreme Court, while generally interpreting the validity of Section 8.4 of the Act, said that under 8.3, the disqualification becomes automatic. But please read the section carefully. The section requires both conviction as well as sentence. Now, in this case, the sentence has been stayed for a period of 30 days. So, can you say that Mr. Rahul Gandhi has been convicted and has sent and has the sentence has commenced, so that he would then be eligible to come back to Parliament only after the 2 year serving the sentence and for a period of 6 years thereafter. So that is not has not been answered specifically by the Lily Thomas judgment of the Supreme Court. I would think that the speaker would have well been advised not to be in such a hurry or such a tearing hurry. After all, since the convicting court itself had stayed the sentence, and there was time for an appeal. The speaker might have at least examined the legal position. He might have sought opinion of the attorney general and of other lawyers.
Do you believe here, like you said, speaker would have been advised not to act in such a hurry? Do you? What happens now? Let's assume that the appeal goes to High Court. The High Court stays
the
a
conviction.
What happens to the disqualification?
The answer is provided in the Lily Thomas judgment. They said that that if the conviction itself is stayed, then the disqualification ceases. But there have been cases where before has been an order of stay, the election commission has gone ahead, announced the elections and held the polls. Then we might have an anomalous situation. So we have had one constitutional authority rushing to judgment. Let us wait to see what the other constitutional authority does.
According to ANI, and this is from earlier this morning, a petition was filed in Supreme Court challenging automatic disqualification of representatives. The plea challenges the constitutional validity of Section 8(3) of the Representatives Act, as you just talked about. What are the odds of this being heard quickly?
I see this is somebody who's filed a petition. I don't think that this will necessarily impact the case. The judges may very well say, "Who are you? What is your locus? Have you approached the High Court?" And there are so many reasons. So I would not like to speculate. The correct course would be to go through the appellate procedure, seek a stay of the conviction. If there is an appeal which is provided under the rules of the Gujarat system for an appeal to the Sessions Court, yes, go there. After that, if you do not get an interim order of staying the conviction, take that rejection upwards to the High Court and even to the Supreme Court.
Mr. Hegde, I want to ask you a slightly broader question, if I may. Just earlier last week, the Delhi police, earlier this week, in fact, the Delhi police registered 44 FIRs and arrested 4 people for posters that were printed. I mean, the Delhi police arrested people who were running printing presses for printing posters that were allegedly against the Prime Minister. Also, in Bangalore, Kannada actor Chetan Kumar was arrested for a tweet on Hindutva that went viral. I can quote similar cases coming out of other states. The Kolkata police arrested a Congress leader for making derogatory remarks against, allegedly making derogatory remarks against Chief Minister Mamata Banerjee on a television show. Is freedom of speech in India under threat, in your opinion?
Well, as far as freedom of speech is concerned, I'm reminded of the late lamented General Idi Amin Dada, who said, "Freedom of speech, I can assure you, but freedom after speech is an entirely different matter." And that is what is happening in India, and that is precisely because these kind of police and other executive excesses do not have consequences even at a later day for the careers of the people concerned who launched that. If courts were to start penalizing people who 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 in the who tend to simply lock up people and throw away the key, then I do expect that before getting into random arrests, the police officer would ask for orders in writing.
Hmm.
I think it is time to fix some kind of accountability. Courts should actually get into the circumstances of unjustified arrests.
Mr. Hegde, Idi Amin presided over a dictatorship. India is a democracy.
India is a democracy, despite all its flaws. But a democracy is not what happens only at the ballot box. Democracy is also running a constitutional form of government in accordance with the requirements of the Constitution. And there we are failing. We are failing because the executive does not stay within the limits assigned by the Constitution. The judiciary tries to push, but sometimes it also looks like it is willing to strike but afraid to wound. Uh, so we are in interesting times, to say the least. There have been people and organizations who have now classified us as an electoral autocracy.
Hmm. What does that mean? What is electoral autocracy? What does that term mean?
An electoral autocracy. See, I prefer to say that worldwide we live in the age of Caesars. Dr. Ambedkar, when he gave us the Constitution, gave us three famous warnings. And the second warning was never put your liberties at the foot of a great man. Dr. Ambedkar was at that point of time thinking about Gandhi, who had just died, and Nehru, who had just started off as prime minister. There is a tendency all over, whether it's the Trumpistas in the United States or the followers of Erdogan in Turkey, then you have Orban in Hungary, and a whole host of things, to just let decisions of life and death be taken entirely upon the say so of a superman. And people keep voting these superheroes back into office just because they like them. There is no rational assessment of their ability to govern in accordance with constitutional limitations. The Constitution very fairly sort of demarcates areas of power, and power has to be held in trust to be worked according to constitutional responsibility. There, I think, as a nation, we are failing to hold our leaders to account. And it's not the first time this has happened. But currently, we possibly have a set of leaders who are more minded to wield the sword rather than to persuade the people.
There is one argument, Mr. Hegde, that what has happened to Rahul Gandhi is just the law taking its course. Because in the pure letter of the law, he has been convicted for 2 years. He has been found guilty, and as a result, he is disqualified from Parliament. Let him appeal and overturn that judgment, or get a different judgment, and then come back to Parliament. Does it necessarily mean our democracy is under threat?
Let's put it this way. How does it look to the outside world? That if a principal leader of the opposition is sentenced for 2 years, for an unprecedented 2 years of imprisonment, and so that it can be legally said that he has suffered an imprisonment of 2 years and is hence disqualified. For what? For defamation, in saying that the Right Honorable Mr. Lalit Modi and His Holiness Nirav Modi and the rest are not available in India. So I do think that there is definitely a, a problem if even the leader of the opposition or a prominent leader of the opposition can't call a spade a bloody shovel.
So you're saying that Rahul Gandhi's statement was an exaggeration, but it did not merit 2 years in jail as a sentencing.
Look, I have not heard of a 2 year sentence of imprisonment in a case of defamation. Many years ago, even before I was a lawyer, I was as a law student when I accompanied my father to court, where a client of his had been sentenced to 6 months for defamation. The judge, Justice Dawood of the Bombay High Court, said, "What? 6 months for defamation? Unprecedented." And so most criminal defamations do not end in convictions. Even when there are convictions, there is always admonition. There's always the Probation of Offenders Act. There are, and sometimes there's a fine, and occasionally a sentence of 1 month, 2 months, or something. Now, with this sentence of 2 years, the question does arise: did the magistrate want him disqualified? And are you going to give the power of disqualifying members of the Parliament or the legislature to a magistrate? So somebody jumps a red light, for instance. I mean, governments change all kinds of things. The next time somebody jumps a red light, supposing somebody says, "Oh, that was a rash and negligent act which could possibly have resulted in a murder, and therefore it is an attempt to murder, and therefore I'm sentencing you to 3 years." Fine. Is that the kind of is that what the law was made of? And so in a sense, this is those who say that this is legal are essentially saying exactly what Shylock said: I have a legal right to a pound of flesh.
The idea that we currently, and I asked you this earlier, I'm going to ask you again, we currently live in an era where owners of printing presses get arrested for posters that get printed. It sounds very British era.
Oh, forget
Is
British.
there a law, Mr. Hegde, under which the owners of a printing press can be arrested for a poster?
Well, everybody who publishes something which is defamatory or which could incite would be responsible. So that would fall within the ordinary IPC. But you can't prosecute everybody for everything in that sense. So somebody asks for posters to be printed. If your role is only printing posters, rarely are you arrested. An excess of application of the law destroys the validity of its application.
Mr. Hegde, thank you so much for speaking with me this evening on this matter and drawing light on criminal defamation as a law in our country and its liberal use at this point. Yes, go ahead.
For your viewers' sake,
yes,
I just want to make this distinction. The criminal defamation law is an anachronism. It is not there in most countries. Civil defamation, where if you say something and if somebody is defamed, then damages, compensation, that is the way to go. Right now in the United States, those Dominion voting machines is suing the Trumpisters who say that they stole the election of 2020. They're asking for $1 billion from Fox News and the rest. That is the way to go. shutting people up for what they say or is certainly not the way a modern democracy should look like.
One last question, Mr. Hegde. We have Kumara in the comment section who says posters pasted on walls without attribution to who's publishing it is illegal. Is that true?
There are requirements for publication that, especially if you publish a newspaper, this man is the publisher, this man and is the editor, and all that. And there are also requirements that when there are posters published, who is the printer? Even if you see a cinema poster, for instance, there's a small line printed at such and such press. That is just a requirement. But if that requirement is violated, does it lead to an immediate arrest? The Supreme Court has, in Arnesh Kumar, laid down guidelines also that before you arrest people, you give them a notice. Was a 41A done in this case? No. See, ultimately, if any set of parties in power tells the policeman, look, I will give you a free hand, no questions asked, then sooner or later, various triggers get pulled.
All right. Thank you, Mr. Hegde, for speaking with us this evening. I know we've taken up a lot of your Saturday evening, but it's, as always, a pleasure to sit down with you. We do hope to have many more conversations with you, understanding our law better. Mr. Sanjay Hegde is a senior advocate with the Supreme Court. To our audience, please leave us comments on other topics and matters of importance that you would like us to bring in experts on so we can understand better. The aim with this conversation is to understand how the law functions better so we as citizens can be better informed. Thank you for joining us. Good day.